9 types of non-immigrant individuals who cannot adjust status. Listen, the way by which you enter the US can determine whether or not you can adjust status. The things that you put on your applications while living in the US can also have an impact on whether or not you can adjust status. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. 9 types of individual, non-immigrant individual who cannot adjust status in the US. Number 1, coup men. The people who are permitted to land as D1 or D2 non-immigrant, C1 non-immigrant to join a coup cannot adjust status. That's just as a matter of law, unless they are also VAWA-based applicant. So this bar does not apply to VAWA applicant. So please just look at your the way you enter the US, right? On your visa, if you enter as a crew member, really, you cannot adjust status. Adjustment of status is the process by which you apply for a green card when you qualify without leaving the US. So you might have to actually leave the US and enter in the different ways so that you can adjust status, or you might have to go outside so you can cancel the processing. Okay. Number 2, non-citizen admitted in transit without visa. They cannot adjust status. This bar does not apply to VAWA applicant. Okay. Number 3, visa waivers program. Admitted without a visa under a visa waiver program. They cannot also adjust status. Number 4, non-citizen admitted as witness or informant. Those are people who are admitted as non-immigrant. They cannot adjust status. The only exception is if they use a special process, pretty much asking the Department of Justice for permission to adjust status. Okay. Number 5, non-citizen removable for engagement in terrorist activities. If you've been charged for terrorist activities or involvement in terrorist activities, you cannot adjust status. That's a permanent bar, actually. Number 6, non-immigrant admitted as fiancé of US citizen. Well, if you're admitted as fiancé of US citizen, the law requires that you marry that US citizen within 90 days. Okay. If you can't marry that person within 90 days, then you're barred from adjusting status. But there is an exception, unless you were married, but marriage, the marriage of good faith, right? Bona fide marriage was terminated either by death, divorce, or annulment, then you can adjust status. Number 7, frivolous asylum applicant. This one I'm going to reiterate a little bit because I have a lot of asylum applicants, clients that apply for asylum. A frivolous asylum application simply states that if the fundamental, right, the material fact of your application is a lie, then the application is deemed frivolous. But listen, they have to give you the opportunity to defend yourself. That's why you go, the USCIS will refer someone to court so that they can present themselves before an immigration judge and defend themselves. And once the immigration judge determined that it is in fact a frivolous application, you have the right to appeal, right? The BIA, you have the right to basically ask for review. But anyway, if you use up all those process and then it has been determined that the application is in fact frivolous, this is a permanent bar. You cannot adjust the status no matter what. Even if you leave the country to go through consular processing, it's like you're never gonna get a green card. This is so important to know. Then we have falsely claiming U.S. citizenship. This one we've always, I've talked about it a lot. So basically, it's just a permanent bar. There's no waiver. There's nothing available for that. You just cannot adjust status. And now it goes even further that if the immigration judge finds out that when they make a determination on a factual fact of your case based on that falsely claiming U.S. citizenship, well, you can't even ask for review. So game is over at on that level. So it's something to really not do when you're applying for any type of application to have a license, employment type of application, stuff like that. Really to make sure that you read those questions carefully so that you don't make that mistake. Okay, and sometimes even if it's an honest mistake, it might lead you to a permanent bar. So, and then number 9, we have fraudulent marriage. So those marriage, like fraud marriage or marriage fraud, sham marriage, if it has been found that the marriage is in fact a sham marriage, you cannot adjust status. But with this one too, you're gonna have the opportunity to actually defend yourself and prove to USCIS that it's not a fraudulent marriage. You really have to make sure that you defend yourself until the end. Because if you lose that opportunity to defend yourself, it's going to be considered that you have been engaging into those fraudulent marriage, and you are permanently barred from adjusting status. Okay, 9 types of individuals. We've talked about it. There are a lot, perhaps too many types of individuals, but today we wanted to focus on 9 types of non-immigrant individuals only. Well, we're here to help. If you need a consultation or you have a question related to those elements that we just talked about, you can either drop a comment below, or if you really need a consultation to assess your case and determine whether or not you'll be able to adjust status based on other factors as well, please call for consultation 202-751-2180. Email Bijoux.ngwandaesq@gmail.com. Consultation fees apply as usual. Until next time, bye-bye.